Hi, this is the Pauline Long Show. It's a very popular global talk show. As you know, watching us from right here in the UK, you can always tune in on Sky Channel 182, that's Ben Television. We want to discuss issues that affect you.
Good evening and welcome to this evening's Legal Hour with myself, Raheela Hussain, Principal Solicitor of Greenfields Solicitors. This show is live on air and I would invite our Ben TV audience to give me a call if they have an immigration, nationality or human rights question for which they require information on. The telephone number to call me live on air is 0208 808 0693. Again, that's 0208 808 0693. I would like to tell our viewers that the information I provide on this evening's show is just that. It is general information to not be relied upon as legal advice. Indeed, if you require legal advice with myself, please do call Greenfield Solicitors offices on 0208 884 1166 to book an appointment with me. Now, as we all know, immigration and human rights is a very, very popular topic. And this evening, I hope I will provide you with helpful updates on the current laws and the current procedures that will help our audience members when they're making an application to the Home Office, or indeed just to provide general information that our audience would find helpful. Now, I would like to talk about a few important points that I feel that members of the public should be aware of. First and foremost, the need to have expert immigration and human rights solicitors to assist them in legal applications. I cannot emphasize the requirement and the need and the necessity to indeed have very specialist immigration and human rights solicitors to help people with their immigration applications. As our members of the audience will know, immigration law is huge, it's vast, it's complex, and it is ever evolving under the current Conservative government. At the moment, migration levels are aiming to be the lowest ever, especially with Conservative government whose aim is to limit migration of foreign nationals in the UK. Therefore, it's a very good idea for people who are looking to make an application in the UK to try and extend their leave here or to obtain entry to the UK, to try and obtain proper, accurate legal advice. Therefore, it would be a very good idea for people to check that their solicitor is registered with the Solicitors Regulation Authority, otherwise known as the SRA. You can do this by going on the SRA website and checking whether a solicitor is well qualified to provide advice in immigration and human rights law, along with finding out how many years they are post-qualified experienced. So for myself, I qualified in 2003 and I currently hold 12 years PQE as a solicitor specialising only in immigration and human rights laws. Now, the other thing that I'd like to update our audience on is the current immigration health surcharge, which the Conservative government introduced in April of this year. The immigration health surcharge, which is something which I touched upon during our last show, was the need for migrants to contribute towards the NHS during their time in the UK. Now, currently, the figure could be around £500 or £600 per time that they apply for a visa renewal or extension, though of course this is subject to change. The IHS fee is made payable directly to the government via an online portal and usually is paid by either a debit card or credit card by the migrant making the application. Now, what's important to note is that where an application is deemed unsuccessful by the Secretary of State, so the application is refused and the person is not granted an extension, leave to remain or a visa, then they may ask for a refund of the immigration health surcharge which they make. In order to do so, the person should keep the login details, so when they logged in on the IHS portal, their name, the password, as they can request this directly, and then the government will refund the money onto their credit or debit card. Another thing to also mention is, in practice, I have noticed I have had clients come to me and they did not realise that the IHS fee was operational from April, and the Home Office have written to them and they have said, dear client, dear applicant, your application is not currently valid as you have failed to make the IHS payment, and in order to do so, and in order for your application to progress, we require you to pay the IHS fee. Now, it should be noted that the Home Office are sending letters currently that allow a migrant up to 10 working days from the date of the letter to make such payment. So it's very important that if you receive a letter from the Home Office stating that you are required to make an IHS fee payment, you do so within the 10-day requirement, as otherwise the Home Office can deem your entire application invalid and return this back to you. Now, I would also like to talk about a very popular topic, which is the right of appeal in immigration and human rights applications. In October 2014, the government introduced new laws, new legislations, which very much affect rights of appeal for migrants making applications. I will come back to this topic as soon as I take a live call. So please do go ahead. Good evening, caller.
Yeah, good evening.
Good evening, sir. Please go ahead.
Yeah, I have a wife that has a resident, but I don't know how people to, assist me in getting my own paper. That's what I want to know, because presently I don't have paper. But she has her own, and we discussed it for a busy for me.
Yes.
She can, do anything. But for now, we have been together for almost 30 years now.
30 years?
Yeah, we have been living together for 5 years. So
Okay.
we don't have any issue.
5 years. And sir, does she hold discretionary leave, indefinite leave?
Yes, he has eyelid key. It's not, he has the eyelid key.
I beg your pardon, what leave does she hold in the UK? What legal status?
She has Taiwan general.
Okay, Tier 1 General. Okay, thank you for your question. Now, to provide you with some general information on that, a Tier 1 General visa is usually something issued to people who are highly skilled. So they're very employable, they have skills, and that's why they're in the UK. But it is important to note that this is a temporary visa, and subject to your wife qualifying, she may in due course be able to apply for indefinite leave to remain. Do you know when she would be eligible to apply for indefinite leave to remain?
Next year. It's going to be eligible next year, December.
Do you have any children together?
No.
Okay. If it's only a few months away when she's actually going to get indefinite leave to remain, then you may wish to consider making an application only after she's got permanent legal status to try and obtain legal status in the UK. Because as you know, at the moment, she's on a temporary visa. There's no guarantee necessarily she'll get indefinite leave to remain. So it may be worth you considering once she actually obtains the indefinite leave to remain for then you to make a further application. And you can do so on a human rights basis outside of the immigration rules whilst you're in the UK to try and obtain legal status. Okay?
All right. Okay.
Thank you for your call. So going back to the issue of rights of appeal. Now, at the moment, we've noticed, particularly following the general election in May 2015, the Conservative government have been doing something which we solicitors refer to as certifying claims. Certifying, what that means is where the Secretary of State looks at a human rights claim, assesses the application and all the points the migrant has raised, and for whatever reason, in the Secretary of State's mind, decides there are insufficient grounds to say that this is a strong human rights claim, and as actually says the claim is so weak under human rights law that we are not even going to give this migrant a right of appeal to argue the case before the immigration judge if the Secretary of State refuses the application. Now, I must say, pre the May 2015 general election, in practice as solicitor, I saw very few certification claims, maybe one a year, if that. Now, since May 2015, we at Greenfields Solicitors have seen clients coming from all different walks with this problem that the Secretary of State has certified their claim, effect saying you are not allowed a right of appeal in country, and if you wish to have a right of appeal, then you're required to go outside back to your home country, be it Nigeria, Ghana, Zimbabwe, and apply for visa rights, for appeal rights from there. Now, as you can imagine, many migrants are not going to be prepared to leave the UK within 28 days, having established a private and family life, in order to go back to their home country in Africa or Jamaica or India, wherever it is, in order to make an application for an appeal. So what does a migrant do in those circumstances? In such circumstances, the migrant can consider getting legal advice and considering making a judicial review application to the High Court in order to have a High Court agree with that migrant that they should be granted an in-country right of appeal. Now, this is not an easy situation. It's quite technical, and it's something that you would need to obtain advice on. And in the meantime, we have another call, so I will come back to this topic again. Please do bear with me. And in the meantime, good evening, caller.
Yeah, good evening.
Hello, madam. How can I assist you?
Yes, my name is Adesemi Iyabo.
Please go ahead.
Yes, my question is that I got married to a British citizen.
Right.
Yes, that was in 2011.
Right.
Yeah, and I was given residence permit this for 33 months.
Yes.
Yes, and I don't know what after I gotten the first 3 months, what is the next step? What step do
Well, it's quite unusual. When you marry a British citizen, you don't usually get 3 months.
No, 3 months. No, 33 months.
Oh, beg your pardon, 33 months. Was this a spouse visa? Do you know what type of visa they granted you? Was it discretionary leave or was it spouse visa?
Yes, they said spouse of, they mentioned my husband's
Spouse visa. And did you get this inside the UK or did you travel out of country and obtain it?
Yes, I traveled out of the country to get it from my home country.
And what's the date of that visa, please? When was it issued?
It was issued in, I think, December 2013. Yes.
December 2013, right. Okay, so usually it's the new 2.5-year spouse visa rules.
Yes, I have planned it to expire next year, August.
Okay, so next year, August, it expires.
Yes.
So what's your question to me, please?
My question is, what other step do I take after, when it's about to expire, what steps should I take?
Okay, so what we would usually suggest in such circumstances is 3 months before the actual spouse visa expires, you should seriously consider obtaining legal representation from expert immigration solicitors, as they would be in the best position to obviously advise you with the ever-evolving immigration laws. And usually what one would do is put an application in for a further extension of a spouse visa for a further period of 2.5 years. Now, spouse visas, as you have found out, they're usually initially granted for 2.5 years. If the marriage is continuing, subsisting, the financial requirements are met, in that there is an £18,600 financial requirement, then the person should
How much?
£18,600, assuming there are no children. Do you have any dependent children?
Sorry, please 1 minute. You need to be a bit slow.
Well, I'm just sorry, giving general information now. So if you do want specific advice, madam, please do call me at Greenfields Solicitors and book an appointment, because we have a lot of viewers watching right now, so I'm limited by time. So at the moment, it's 18,600, the financial requirement if you have no children. And then you would just make a visa extension for a further 2.5-year period to obtain a further spouse visa. And on this occasion, this application is made to the Home Office in the UK. And assuming that the documents are fine, you filled in the valid application form, you paid the Home Office fee, the immigration health surcharge, then hopefully you should be granted a further 2.5 years. At the end of that, you can then apply for indefinite leave to remain. Okay? Thank you very much for your call.
Right.
So continuing what we were discussing just before our last caller, judicial review High Court applications, these are quite costly in effect. Solicitors do charge, barristers do charge, and many migrants are unfortunately not in the position to sometimes financially satisfy the legal fees required. So there is also maybe another option available to a migrant, and that's sometimes where the Home Office gives an opportunity to make a further representation, so the migrant can say, look, I disagree with the refusal decision and I disagree with the fact that you've certified my claim, and as such what I would like to do is put further grounds to you that I have not raised before or failed to raise before for you to reconsider. And this is under section 120 of the Nationality and Immigration Act, whereby one could put in further grounds, so you can ask the Secretary of State to reconsider the matter and indeed not certify the claim, and rather to grant an in-country right of appeal. In addition, you can also ask the Secretary of State to consider that if there are children in the family, that they should be given priority. Children's rights kick in, migrant children. The UK is very, very keen on obviously looking after the legal rights of children, and things such as Section 55 of the Border Citizenship and Immigration Act would also be of great use. And the Home Office are told that, look, where there are minor children of the family, they should grant in-country right of appeals. And indeed, at Greenfields Solicitors, we are seeing that happen at the moment. Now, I believe we have another call, so I shall take that call as well. Good evening.
Good evening.
Hello, madam. Please go ahead.
Sorry, I just want to ask about a child that is nearly 7 years old.
Sure, yeah.
So I want to know what I want to do. I want to do application for her. But she's not 7 years. But I heard something that I'm not sure about it. I heard that they are giving people decisional leave to remain under a child that is less than 7 or probably prior to 7.
Are you yourself also unlawful? Do you have status?
No.
Okay, and how many other family members have no status?
I'm just myself, I'm just a single mother.
And you've not made an application before?
I have.
You have?
Yeah.
When did you make that?
February.
Very recently?
Yeah.
Okay, and relying on the child?
Yeah.
Okay.
I relied on the child.
But obviously the child was probably 5 or 6 years old, and you're saying that the child will be 7 soon. So what can you do in terms of making a new application, right?
Do I need to, they don't really answer me about the application. She's just 6 years plus now.
Okay.
They've not said anything yet.
Yes, there are immigration rules that currently say where a child is age 7, so usually either the child has been born in the UK and is age 7 or above and has spent all their life in the UK, or, for example, a child came in from Nigeria aged 3 and the child is currently 9 and therefore has spent 7 years in the UK, if not more, then the immigration rules do state that a migrant, the parent of the child and the child can put an application to the Home Office and request that they be granted discretionary leave to remain, as our last viewer correctly identified. Now, this is based on the fact that the child has obviously climatized to living in the UK, has become familiar with the procedures, schooling, speaks English, understands British culture, and that it would be very difficult and unfortunate if that child was removed from their life in the UK to some foreign country where their parent is from. So indeed, it is worth looking into making an application for discretionary leave to remain once a child has accumulated the 7 years residence in the UK, and obviously they have to be a minor when the application is made, so under the age of 17. And the Secretary of State does have the powers under both the Section 55 of the Children, Borders, Immigration, Citizenship Act in 2009 and under Article 8 of the Human Rights Act to grant that migrant child and their family members leave to remain on a discretionary leave to remain basis, which is for 2.5 years. So with our last caller, again, please do try and obtain expert legal advice. Thank you. And now we will go on to the topic of, which was to do with children, actually, the rights of appeal. So where you do have a child of the family, do get your lawyers to write to the Home Office and say, look, we have children of the family, do not certify this, we do not accept it, let's have an in-country right of appeal, and hopefully they will seek to grant that. Now, I'm pleased that we're getting questions from our viewers this evening on spouse and fiancé visas, civil partnership visas, as actually that is what this show seeks to answer this evening. I would like to focus on spouse visas and fiancé visas and civil partnerships, which are both obtained from outside the UK and in the UK. So if any of our viewers have questions on this topic, please do give me a call again on 0208 808 0693. I'm live on air now. Alternatively, if you would like to book an appointment with me at Greenfields Solicitors for specific legal advice, please do call our offices on 0208 884 1166 or go to our website, which is www.greenfieldsolicitors.com. Now, as I was mentioning to one of our earlier callers, there is a financial requirement of $18,600. So usually the British sponsor or the sponsor in the UK who holds indefinite leave to remain is required to earn at least $18,600 in order to sponsor a foreign spouse to enter the UK with either a spouse, fiancé or civil partner visa. Just to clearly define the differences, a spouse visa is obviously if there is a husband and wife relationship. A fiancé visa is where a couple are not married, but their intention is to marry, so they are fiancés. And finally, a civil partnership marriage is same sex, so a gay couple or a lesbian couple seeking the same leave to remain or enter. Where there are children of the family, the financial requirement and the children are not British. So, for example, let's make a scenario here. We have a British citizen husband. He's fallen in love with a lady in Ghana. He goes to Ghana, he marries her, and he wants a Ghana lady to join him in the UK as his spouse. The Ghana lady has, for example, a 12-year-old son from a previous relationship, and she says, look, I need to obviously bring my son to the UK as well. So long as her British spouse in the UK has been earning, in this case, not only $18,600 for her, but also because there is a child of hers, the financial requirement goes up to $22,400. So if her British spouse is earning more than $22,400, which therefore encompasses the financial requirement for her and her dependent son, then he can make an application to sponsor her to come to the UK. Now, as we find in practice, this is not a small figure. Many people do not earn £18,600. Indeed, if there are children of the family, people don't generally earn in their 20s, 25,000, unless they are obviously well educated, have skilled jobs, or they're lucky enough to have employment or self-employment that earns that amount. Now, I'll just come back to this topic once I answer our next caller. Good evening, caller.
Yeah, good evening.
Good evening. Please go ahead.
Yes, I'm calling regarding to the resident permit I was given.
Under European law?
Yeah, under my baby. I was given the resident permit.
Is that for 10 years?
No, it's for 2.5 years.
Okay, was that okay? Just give me some circumstances. Is your child British?
Yes.
Okay, sure.
And but now we separate, not divorce. And the baby we have, the baby died.
Oh, I'm so sorry. I'm very sorry.
We have actually divorce as well.
Sure. And is your husband, is he British as well?
Yes, she's a British.
Okay. And what would you like to ask me? What's your question, please?
Well, my question is, I don't know what am I going to do next because I'm going to renew my resident permit.
Sure. Do you know if you're on a spouse visa or discretionary leave?
It's under the baby.
Yeah. There are different visas, so the only way I could actually confirm which visa you're on is by actually looking at it. If it is under the baby, I'm assuming it's discretionary leave to remain if the child was British. I'm very sorry to hear that obviously your child has passed. However, if you're also divorcing your partner, the Home Office, you can make an application to the Home Office, of course. You are entitled to try and make an application for further leave to remain despite these obviously very sad circumstances. You will have to explain to the Home Office in your application, despite the massive change in circumstances, why you seek further leave to remain in the UK. So you would need to argue your private life here in the UK compared to what your circumstances are back in your home country and why you can't establish yourself back there. What is keeping you here? Maybe you're in employment, maybe you have a skill set. So you really need to make something a compelling, compassionate case, which really evokes the Secretary of State to realise that you do have a human rights claim, usually under Article 8. Maybe you've established a private and family life in the UK. What I would suggest you do is maybe get specialist legal advice. If you'd like to book an appointment, then please do call Greenfields Solicitors and I can go through it in more detail with you. Thank you for your call. So going back to the point of what do we do with migrants who, or their partners rather, in the UK who don't earn the financial requirement of the minimum of $18,600 to support a spouse, fiancé or civil partnership visa. In such circumstances, where a foreign migrant spouse Zimbabwe or Kenya to apply for this spouse visa, I know I'm not going to get it because my husband or my wife doesn't earn the $18,600, then it could be possible to apply for discretionary leave to remain. This is an application which again is made in the UK to the Home Office, to the Secretary of State, where one can argue, look, I'm not going to get a spouse visa if I go back to my home country because my spouse does not earn the financial requirement. One would argue we are married or we have a serious relationship and therefore it's ridiculous to suggest that because of financial requirement, my husband and I or my wife and I can't be together. So can the Secretary of State overlook this and grant me discretionary leave to remain for an initial 2.5-year basis period, which allows you to live and work and reside lawfully in the UK? Now, each case is determined on a case-by-case basis. So the Secretary of State will look at the merits of each individual case, how long that foreign person has been in the UK, maybe what the salary is of their spouse. You know, maybe they don't just earn the 18,600, they may just earn 14,000 or 12,000. They may look at if there are any family of the children, and I can tell you in practice, if you do have family of the children and the child is British or has lawful status, that very much does help in discretionary leave to remain applications. So there are numerous factors that the Secretary of State will look into. Again, I would say to any of our viewers who are facing this predicament or they're unsure what their options are, to get expert immigration and human rights advice from legal representatives who are well qualified. So what else we need to touch upon during this show is the aspect of what do you do if you have a criminal record in the UK. So sometimes we have migrants, they haven't necessarily got serious criminal records. They may just have, you know, petty crimes such as theft or something like that in the UK, or driving or fines or speeding bans and things like that. And they're worried, will the Home Office still grant them legal status if they make an application to remain? Generally, where a person has not gone to prison, so they haven't served time, but instead maybe they got a community service order or a fine